It's time for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. And now your host, J. Bryan Nugen, estate planning and elder law attorney.
Good morning and welcome to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. I'm attorney J. Bryan Nugen, founder of Nugen Law and your host for our program. The purpose of our show is to have weekly, in-depth conversations about matters relevant to folks as they walk down the path of successful aging. Our listeners will learn what it is to age with dignity and how best to protect their money. I've been practicing law for 3 decades. I'm licensed to practice in Indiana, Ohio, Michigan, and Florida, and I actively represent clients in all 4 states. My practice, the attorneys, and our interdisciplinary team of professionals who practice with me concentrate on working with clients in estate planning and elder law, and areas related to them, such as estate and trust administration, guardianships, and planning for those with special needs. Today's guest is Jeslyn Smith, an attorney with Nugen Law. Jeslyn is licensed to practice law in Indiana, has been doing so in excess of a decade, and is currently serving as president of Indiana's chapter of the National Academy of Elder Law Attorneys. Quite a title. Welcome, Jeslyn. Great having you on.
Thank you, Brian. I'm excited.
Good. That's great. Jeslyn, let's just begin with, would you please describe what's a guardianship?
A guardianship is when an adult usually is unable to make financial and healthcare decisions for themselves any longer. And that can be because of a disability or any type of accident or something that has happened to the individual which changes their ability to make those decisions. And so then with the guardianship, we have to go before the court and ask the court to appoint someone in order to make those decisions for them.
So that's a lot to unpack. What attracted you to practicing in the area of guardianships, Jeslyn?
Well, with our area of law, with estate planning and elder law, a lot of times folks don't understand the importance of having documents ahead of time and having those in place, naming someone to make those decisions for them. And so with that, sometimes we need to step in and take care of that for the clients in their time of need. And so I felt a passion in helping individuals and getting that and going to court and helping them through that process. Because when individuals hear court, a lot of times they're afraid or scared because of what they see on TV and things like that.
So when the court's making the decision about whether or not someone should have a guardianship, is it just the court that's making that call, or who's called upon to assist the court in making that decision?
Well, so the court usually appoints a third party that's neutral to help them make that decision, and that person is called a guardian ad litem, and it's usually another attorney that the court appoints, and that attorney's job or role is to look out for the best interest of that incapacitated adult and to make sure that this person actually needs the guardianship. And so they evaluate the situation, they interview all of the parties involved in the situation, and they look at, is this appropriate? And they make a recommendation to the court when we go to court for the hearing day.
So would that guardian ad litem be speaking with the family doctor or the doctor for the potential person that's going to be in the guardianship?
They can. Usually we request ahead of time from the doctor to prepare what's called a physician's report, and they give their recommendation based on that report as far as if they believe their patient needs a guardianship or not, and what level of care does that individual need, and also usually is it safe for them to be able to even participate in the hearing and the proceedings with us. And so once we have that report, we provide that to the guardian ad litem. But if the guardian ad litem feels like they need additional information, they can go to the doctor and ask the doctor for additional information concerning the person's capacity.
Will they also interview the person or speak with the person that the guardianship is about?
Yes, they actually are supposed to meet with that incapacitated adult. They need to find out if that adult actually is unable to make those decisions. So it's kind of hard to make a recommendation without actually meeting that individual. So yes, most guardian ad litems will go meet with the incapacitated adult, try to find out about them, and evaluate their capacity. That's also why the courts like to appoint an attorney in that role, because that attorney is going to be looking at the incapacitated adult as in the position of, do they have the capacity?
Mm-hmm. Excellent. When are you normally approached about forming a guardianship? For whom are they appropriate? You mentioned earlier about capacity, and you also used the word disability, but I want to make sure that we have a distinction there. There's a physical disability and a cognitive or a thought process disability. Is there a difference between the two in relationship to guardianships?
Well, there can be, but there may not be, actually. So if you look at when we're approached for a guardianship, it's usually when someone hasn't prepared documents ahead of time naming those individuals they want to be able to make their financial and healthcare decisions. But it can be a cognitive disability. It could be a physical disability too, depending on what it is that's limiting them to be able to handle and manage their financial and healthcare decision making. So it could be one or the other.
And I got you off track a little bit with my question. Thanks for that, Jeslyn. But so when are you normally approached about initially forming a guardianship?
Normally, I'm approached with forming a guardianship when someone's usually in a facility or in the hospital, and the doctors are saying a lot of times, this individual needs a guardianship because we can't ask them what it is they want to consent to or not to for their treatment. And so then the family will schedule an appointment, come in and meet with us, and then we talk through, is a guardianship necessary, or do we have least restrictive means? Because Indiana does have a standard that they want us to look at lesser restrictive means in order to accomplish the goals for the individual. So can the individual understand maybe like a healthcare power of attorney or healthcare representative designation form, or financial power of attorney? And so we have to evaluate, is it even appropriate to be going to court in this situation, or can we use something least restrictive?
You talked earlier about guardianships normally for older folks, older adults, but there are times when they're also appropriate for younger individuals. So I'm a parent, I have a child that's maybe 17 years of age. We know that they have some cognitive issues. They're hitting that 18th birthday. So normally, if you don't have cognitive issues at age 18, you are recognized as being mature and able to be acting on your own, of legal age. So what happens for parents that have a child maybe that's 16, 17? They know that 18th birthday is arising. Are there times in that set of circumstances that you're called upon to assist clients as well?
Absolutely. I'm glad you brought that up. That is another situation and time in which individuals will come in and say, I need to get a guardianship because my son or daughter is unable, when they turn 18, to be making financial and healthcare decisions for themselves at that time. And so we will go to the court and look to have a guardianship put in place at that time too. The nice thing, too, about Indiana, though, is sometimes someone may be able to eventually not have a guardianship in place. So we can also look at using other tools within our guardianships to accomplish it too, such as supportive decision-making agreements. So I have used those before with my clients that have children that are just turning 18 and not able to make those financial and healthcare decisions. But we set maybe some guidelines in order for the kid to try and manage some money and see how that goes, and see if at some point that guardianship can be terminated later on. But yes, we do have situations where we help folks get guardianship over kids that are just turning 18.
Excellent. Thank you. So the process for establishing a guardianship, they're reaching out to you, Jeslyn. They're expressing those that may be eventually the guardian. They're expressing a concern for a child, an adult. So they're communicating with the attorney. The attorney, sounds like, is getting in touch with someone called a guardian ad litem to make a report to the court. We've gone through the process, and the guardianship is established with the court. Have you heard? I recall hearing some pretty salacious things in the news about guardianships that were established that maybe shouldn't have been established. Have you heard of horror stories in the news about people being placed in a guardianship who may really not have needed one? How do you avoid establishing a guardianship for someone who may not really be appropriate for one?
Yeah, again, that's where I look at evaluating the situation with the family to make sure that the individual we're trying to get guardianship over really truly needs that guardianship, and having that conversation with the family members that are trying to seek that guardianship and say, is it really appropriate to be going for the guardianship? And if it truly is appropriate, then we're going to go through those proper steps to get them appointed, and then following the rules. The courts have safeguards in place for individuals because the courts take it seriously that we're stripping away the rights of this individual to make their own decisions for themselves. And so there's reporting requirements to the court that the family is going to have to do. We have to prepare an initial inventory to the court to say, this is what this individual owns. And then every 2 years, the court requires that appointed guardian to actually report to the court what's been done with those assets. And so they're actually held more accountable sometimes than a financial power of attorney is, because on a financial power of attorney, you usually are not providing a accounting unless you're asked for it. But the court requires in guardianships that you have to prepare that every 2 years.
It's interesting you talk about folks that are in a guardianship not being able to make decisions and having some limitations, making that guardianship appropriate. But does that mean that the person that is subject to that guardianship, that they can't work, they can't be in the community, that they're, how does that affect them individually once that guardianship is set up?
Well, it's not that they can't work or go out into the community or do things for themselves. What the guardianship does is it protects them from being taken advantage of. So like in contractual agreements and things like that.
I like that. So they can't be taken advantage of. That's a great way of saying it.
Yeah. And so somebody can't try to come in and prepare a contract for them and it actually be legally binding. Mm-hmm. So the guardianship kind of helps shield them from being unduly influenced or taken advantage of.
So if someone is in a guardianship, they're subject to the guardianship, and they do sign that contract, somebody came to them and said, hey, I'm going to sell you this or sell you that, and they ended up signing an agreement. Is that agreement enforceable then? Is it not enforceable? How does that work?
It's not enforceable because the guardianship has been established. There is a guardian, and that guardian is the person that has to sign for those contracts and everything for the individual. So that contract would be void.
How long does it normally take to get a guardianship established?
Well, so usually right now I tell clients we can get into the court to see the judge usually within 30 to 60 days. Usually the court hearing will be established, and then we go and meet with the judge, and during that hearing, the judge will make their decision. So usually from the time we meet with them until we get to the court hearing, we're looking at about 60 days usually.
Is there a process whereby it could go more quickly if someone's in harm's way or they're being taken advantage of in a significant manner? Is there a way to get in faster than those 60 days?
Absolutely. So we can ask for a temporary guardianship, and that's where we can usually get into the court within a week if we can show that there's some actual harm being done to the individual. The guardianship needs to be established faster. And so we have to show that there's an imminent harm that is occurring with the individual, because with that, a lot of times the notice requirements that Indiana requires, because we have to give notice to the individual that, hey, we're filing for guardianship over you, because they do have a chance to voice their opinion and dispute the fact that somebody's trying to get a guardianship over them. And usually if we're trying to get in within a short period of time, those notice requirements are usually waived, or we have to try and get personal service like hand delivering the actual notice to the individual in that short period of time. But that temporary guardianship, once it's established, it's only good for 90 days. And so then within that 90-day period, we need to petition the court then if we need to convert it to a permanent guardianship.
Excellent. And in those temporary guardianships, do you also have the guardian ad litem appointed for the individual in such a short time span?
Yes, we do. We have a guardian ad litem appointed, and they try to get out to see the individual before we have the hearing within that week.
Excellent. So is the guardian ad litem remaining appointed for the benefit of the person subject to the guardianship for the length of the guardianship, or is it just for a limited period of time?
It depends, actually. So it can be a limited period of time, usually until it's established. And then the guardian ad litem can be discharged from that role or duty. And that's usually when we're not in an uncontested matter. When it's a contested matter, usually the guardian ad litem will stay to help facilitate any conflicts and things going on between maybe some of the parties and the players. So, and that would be like maybe the guardian and maybe some of the family members that are concerned with who's been appointed and things like that. So the guardian ad litem may stay in that role, but most of the time when it's uncontested, they are usually discharged from that role after the initial appointment of guardian.
Let's talk about that, contested versus uncontested. Would you define that for the listeners, what the difference is between the two?
Yeah, so an uncontested matter is when the person that is trying to be appointed as guardian and maybe all the other family members that are involved that have received notice all agree, and they are okay with who's being appointed, and they also agree that this guardianship needs to be established. In a contested matter, usually that is when one or more people want to be the ones appointed over this individual, and so then the parties are then fighting over who is going to be appointed as the guardian over the incapacitated adult.
So the concept of being contested, is that also in relationship to the person that's alleged to be incompetent, that they could be contesting the guardianship?
Yes, absolutely. So if they're saying, I'm not incapacitated, and they are trying to defend that position themselves, it would also be a contested matter at that point.
All right. And is the individual that's potentially being part of that guardianship, are they able to hire their own counsel? Are they able to request that the court loosen up monies from the potential guardianship so that they can hire an attorney and represent them in the courtroom aside from that guardian ad litem?
Yes, absolutely. They can hire their own counsel outside of the guardian ad litem. Everyone's free to have their own counsel and to hire. And so, yes, they can ask for their own counsel.
And have you seen a situation where there's a guardianship established, but it's limited only for certain types of things? Is the guardianship relevant or?
Absolutely. I've actually served in the role as guardian ad litem in a case for a individual that was turning 18. And again, we established what was called a supportive decision-making agreement that allowed some flexibility for this child to have access to some funds. So they were allowed to have an account with up to a certain specified dollar amount in which they could manage on their own and try to handle and take care of. And so we can set limitations within the guardianship as to what powers and what things the guardian actually has control over.
You were mentioning earlier about guardianships maybe going away at a certain point in time if an individual is found not to be incompetent any longer. With the limited guardianship where the individual is given access to some of their money and learning how to manage the money and is spending it appropriately, etc., would that be a way for us to incrementally determine if somebody should or shouldn't have a guardianship removed from them?
Absolutely. And that's why we like to use those tools, because it kind of establishes that baseline of have they been able to learn how to take care of making those financial decisions for themselves.
And so we've talked about the guardianship, and obviously it's something that's going on a regular basis in every county, at least in this listening area. But is there a way for us to, in advance, set things in motion such that a guardianship may not be actually implemented?
Absolutely, and that's through having your estate planning documents done. So you have a financial power of attorney where you appoint someone in the event you're unable to handle your finances that can step in and take care of those finances for you and managing things. And the nice thing about having a financial power of attorney is that you still have the ability to manage your finances and everything without being stripped away of that right to make those decisions. And that's why we call that a least restrictive mean, because you've appointed someone that you trust in that position to take care of those financial decisions for you if you become incapacitated or unable to handle those things.
So we're assuming something there, Jeslyn, and the assumption is that the person that's signing those documents at that time has capacity to make them.
Correct. Yes, they have the capacity to understand that they're appointing someone that's going to be in charge of those finances when they can't, and that they can appreciate the fact that they are naming someone in charge of those finances and who they want that to be.
All right. And we're focusing a lot on finances and money in the guardianship and those reports that need to be filed every 2 years with the court for the individual that's subject to the guardianship. But let's also talk about on the healthcare making side. So there's more to a guardianship than just managing one's money. Is that right?
That's correct. So that's guardianship over the estate, but you can also get guardianship over the person, which is then making their healthcare decisions for them. So they're not able to appreciate or understand the nature of maybe a surgery or something that they need. So that guardian is the one that's consenting to that medical care that they're receiving if they're appointed as guardian. And then also with that, you have to report to the court as far as where the individual is residing as part of that 2-year report if you're also appointed as the healthcare decision maker guardian.
Are you able to sign documents in advance to appoint in advance of a guardianship when you have capacity to appoint someone that could make those healthcare decisions on your behalf. You referenced you could appoint someone to make financial decisions for you. Can you do that for healthcare decision making as well?
You can. You can appoint someone through a healthcare representative designation form, and you would choose who that individual is that you would want to make your healthcare decisions. And with the healthcare decision representative form, that form is in place for when you're unable to make healthcare decisions. But as long as you're able to make your own healthcare decisions, the doctor's going to let you make those healthcare decisions.
That's a great point. I always chuckle when I have clients that are signing that healthcare rep designation or signing a power of attorney. They have the impression that by signing those, it is like a guardianship, but they really are nothing like a guardianship. Is that right?
That's correct.
No, you're planning in advance, hopefully, to avoid the need of a guardianship in the future.
Yep.
And there's an expense that comes with a guardianship, right?
Yes, that is correct.
Okay.
Because you're going to have the time of preparing the documents, you're going to have time in court, and you're going to have the time prepping the inventory and the accountings. And so there is a cost associated with it. So it's far more costly because it's ongoing. Whereas if you're preparing in advance, you're usually having a one-time cost to prepare those documents.
Mm-hmm. And how far in advance should folks be signing those documents that could be used to appoint someone to make decisions on your behalf regarding finances and health care so you can avoid a guardianship? How far in advance should those things be in place?
I think it's situational, but anyone over 18 that is an adult that has the capacity to make that decision should have documents in place, because you never know what's going to happen in life, and you could be in a car accident and in a coma or stuck in the hospital for months on end with no one in place to make those decisions for you. So I think it's good for anyone that's an adult to have those documents in place.
And let's dispel a myth. The myth is that if I'm married, my spouse can automatically make financial or healthcare decisions for me. Or if I have children, my children can automatically step in and make financial or healthcare decisions for me. Jeslyn, in your experience, is that how it works?
No, absolutely not. When clients come in and they say, I was trying to access my spouse's IRA, they're in the hospital and I need to be paying the bills, they're not working. Mm-hmm. Well, your name's not on that IRA or that 401k, and so just because you're married does not give you the legal right in order to access those assets. The only assets you have legal access to are the ones that you hold joint with your spouse.
I think people are always surprised to hear that.
They are.
And in fact, sometimes we need to have guardianships established because the spouse, the loved one, no longer has capacity. They didn't put those documents in place that you were referring to earlier, that durable power of attorney or the healthcare rep designation. And so here we are, our loved one's in the hospital. We knew they were ill for a period of time, but we've kind of ignored the situation, and now we need a guardianship. And that's a tough thing to hear for folks to hear. How often are you seeing guardianships established versus folks having those documents in place, the POAs and the healthcare rep designations in place? Are you seeing guardianships happening just on a weekly, daily basis, or it's more of a rarity?
It's more of a rarity, really. I would say I may do 10 to 15 a year total, so maybe one, possibly two a month.
In your practice?
In my practice. But I'm not seeing it weekly or daily.
Thank you. So thanks for joining us today, Jeslyn. I really appreciate your insight. You've really given us some information that's essential in relationship to guardianships. If someone would like to meet with you in person to discuss guardianships, estate planning, or other elder law topic, how is it that they can get a hold of you?
They can contact our office at 260-925-3738.
All right. And you also can reach out to us at help@nugenlaw.com. Thank you, Jeslyn.
Thank you.
Thank you for listening to Life Care Planning with Nugen Law and to our guest, Mrs. Jeslyn Smith. I look forward to next weekend, Saturday at 9 a.m. here on WOWO for Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law.
You've been listening to Preserving Your Dignity and Your Money, Planning for Successful Aging with Nugen Law. For more information, log on to NugenLaw.com or email help@NugenLaw.com. Nothing stated in today's program should be considered as legal advice, should not be considered as having created an attorney-client relationship between show host and guests and any listener. Nugen Law is not liable for anything that happens as a result of a listener relying on provided information as legal advice. The content is for informational purposes only.